All right, welcome back. So this should be a somewhat lighter week because I think we've already summarized most of the stuff that you've had in the readings for this week and earlier weeks, and especially in the last capsule, which was part 1 of Chapter 6. So Chapter 6 is on procedural fairness obligations. I'll repeat it because it's been a while with the reading week, but the procedural fairness obligations that apply, first, as we said earlier, will always apply. They always apply because they apply by virtue of the Constitution. So it doesn't matter within the administrative context that the statute does not provide for either specific procedural fairness obligations, so, for example, the right to a hearing. It also doesn't matter that the statute does not provide for any procedural fairness obligations because the procedural fairness obligations are inherent, right? Unlike jurisdiction, we said there's no inherent jurisdiction. It's granted by statute. So everything that's in the statute is the power, nothing more, nothing less. So procedural fairness is different. It's inherent. The Constitution imposes procedural fairness obligations in the administrative context inherently, right, by virtue of its application to the administrative context, and therefore it does not matter that the legislator has within the statute that defines the nature of the administrative power, and that statute's important for the reasons we just mentioned, right? It's the entirety of the power devolved to the decision maker. It doesn't matter that the statute does not provide for procedural fairness obligations. They will apply. As a corollary of that, if the statute provides for some procedural fairness obligations, they're not necessarily dispositive. So it might be that, right, they're not sufficient. Usually the court will take account of the procedural fairness obligations imposed by the legislator, right, because there is a certain degree of subjectivity to it in administrative law, right? Administrative law tries to provide a flexible decision-making context that is all the things we said: more specialized, cheaper, more efficient, simpler, and therefore less procedurally guaranteed. Less procedurally guaranteed than a court, right, where you have all sorts of rights, right? You have the right to have your evidence, you have the right to have your witnesses talk about the evidence, cross-examine the witnesses on the other side, preliminarily examine the witnesses on the other side, object to everything, right? It's all very, very procedurally fair, but again, only to the extent that you can pay for that, because it has a cost. So the administrative context tries to simplify that, make it cheaper. Therefore, there's a level of discretion, to call it that, on the part of the government. So the government's going to be allowed to limit your procedural fairness somewhat, because that's the whole point. The whole point is it's cheaper and more efficient, but the cost of that is that it's potentially less fair, right, to some extent. But when it's too unfair, then the procedural fairness obligations that apply by virtue of the Constitution will trump that and apply. So the statute, so the government by statute provides for something, so it says these are the procedural fairness protections that you do have, right? Namely the right to have an oral hearing, but not something else, not present witnesses. You'll just have to talk yourself, right? That will be helpful. The court will take that into account. It will say the government has duly considered, most likely, that it wanted the mechanism to be fair while also reducing cost. But it's not dispositive. If it's not sufficient, the Constitution will apply. If it's not within that degree of discretion and subjectivity that you can have, the Constitution will trump that, it will apply, and will prevent the government from overly limiting your procedural fairness obligations. As I said, the other context that we see is where you just don't have any protections provided for under an act. Of course, that doesn't mean that you have no procedural fairness. It simply means that, right, the obligations will be determined by the courts at the time where it's relevant. So when someone will say, this process does not provide for sufficient procedural fairness protections? Well, the first question that the court will have to ask is, which procedural fairness protections do exist? It's going to have to conduct a constitutional assessment and see which procedural fairness protections do apply. Then it will have to see whether or not these protections have been met. So, and sometimes you'll have kind of a hybrid where the administrative decision maker will have the power to design the procedure, right? That can be a power that's discretionary or regulatory. So either make it up or make it up pursuant to regulations, which are just, right, sub-laws enacted pursuant to a law that gives the power to legislate administratively, right, pursuant to the framework we saw. So decision-making power versus rule-making power, both of which are administrative and provided for by statute. So decision-maker might have the power to design the procedure, and then the court will control whether or not that procedure is constitutionally permissible pursuant to the constitutional procedural fairness protections that will apply. As we said, by default, you have a presumption of reasonableness review, right, subject to all the things we saw, I think, in the last capsule. So you have two sources of procedural fairness. The distinction between both doesn't really matter for purposes: natural justice and the duty of fairness. So first you have to have, right, a clear description of the procedural fairness protections that will apply. So of the procedure, that will be followed. So it will be procedurally unfair if you don't know what you're getting into. So for example, if you don't know whether or not you have a right to have witnesses heard, that might impact some earlier action of yours, so you might not, say, produce as much documentary evidence if that's the case because of that assumption. And therefore, it has to be clear what the procedure is, right, for it to be fair to you. So again, it can be designed in various ways by various entities, but it cannot be unknown to you as you get into it. Then you have a bunch of contextual factors, which are mentioned at page 282, which are essentially what we said. So first, the statute will be helpful, right? So it will either set out certain procedural fairness protections, and it will set out potentially, right, a procedural, we'll call it context. So if the statute says you have a right of appeal, you'll recall that was something that would limit the deference owed by the courts. So if the statute does not provide for statutory right of appeal, what we call a privative clause, it says this decision is final. Again, it can never be final because the law says you can always go to court to seek judicial review of that decision. But if the statute says it's final, right, that is evidence of an intent of the government to limit your ability to seek judicial review. The court will take that into account. On procedural fairness, it will be less deferential because it wants to ensure that procedural fairness protections are met. And if the statute says, right, you have nowhere else to go, essentially the court, upon judicial review, if there's no appeal tribunal within the administrative system, the court will be your only and your last resort. Therefore, the court will be less deferential, less reasonability standard, right, in assessing that, and will really want to make sure that the proper procedural fairness protections have been followed. Same thing with the distinction between a preliminary and a final decision. A preliminary decision is not final, right? So it doesn't affect your rights as much. A final decision is a final determination or disposition on your rights, and therefore it will be, right, subject to greater procedural fairness protections because it's final. It has a greater impact on your rights, therefore we'll really want to make sure that you were heard, not as much for a preliminary issue that might eventually lead to a final decision where, for example, you might have an opportunity to be heard differently. So there's a preliminary objection to your evidence, you'll be able to submit some other evidence. So less procedural fairness obligation. Same thing as a court. We don't let you go appeal every single interim decision of a judge within case management. Then you have the circumstances, which are always important. That's what we discussed so far. Then you have the power of the decision maker. So the nature of the decision maker and the task that it performs, which is kind of like saying you'll consider the circumstances that will impact the level of procedural fairness protections that will apply. And you have the last two factors that are mentioned there is the individual litigant, and fifth and most importantly, the nature of the decision. So the individual upon whom a decision is being made will help determine the level of procedural fairness protections that will apply. For example, if it's a vulnerable person as opposed to a corporate entity, you'll have greater procedural fairness obligations. Similarly, the nature of the decision will be important. That's what we said under our earlier framework, which was kind of a simplified version of that. We said it depends on the nature of the decision and its impact on you. So if it's a big decision that takes away a lot of your rights, you'll have, for example, sends you to some other country to die. You'll have a lot of procedural fairness apply because we really want to make sure it's done right. So the nature of the decision and its impact upon the person's life. Okay. Upon our earlier framework, we said there's essentially two portions to your procedural fairness rights, which are best understood as, I didn't write it that way last week, but essentially the right to talk and then the right to be heard. So first, the right to express yourself, which is the right to be heard, right, is to put forth your case. The ability to know what you are responding to. What is the allegation being made against you? And be able to respond to it by, say, producing evidence, right, witnesses and all that, which all relies upon you knowing what you're actually responding to in the first place. So that is from the perspective of the litigant, from the perspective of the party, the person who is facing the administrative system, right, has a certain ability to put forth their case. The second portion of that is that it has to actually help, right? So the person on the other side, the decision maker, has to actually hear you. They can't be biased. They can't plug their ears as you're making your case. That would also be unfair because you'd be talking at nothing, right? So you have certain obligations of usually the decision maker that have something to do with ensuring that you have an ability to impact in some way the ultimate outcome of the case. Okay. Then there's a discussion of cost-benefit analysis under maybe case, which is really a permutation of what we discussed earlier. So we said the government has certain discretion to limit procedural fairness. So although the procedural fairness obligations will apply inherently by virtue of the Constitution, it doesn't mean that you'll have as much procedural fairness protection as you would in a court. In fact, you won't. The government can limit it somewhat. And the Mavi case essentially says that. I'm at page 284. We've gone over 3 pages so far. The case says you engage in a cost-benefit analysis, which is really what I said. So first, what will the cost of an additional procedural fairness protection be? And then, is it worth it? So usually, what will the impact of not having that procedural fairness protection be on the person who is being heard, right? So that will often be a risk of inadequate determination, a risk that you make a mistake because you don't have the whole case and the person hasn't had an opportunity to contest everything. And then you weigh the two, right? So the cost of the measure versus its impact on not having it, right? The impact, sorry, of not having it on the process and eventually the person. Okay, then there's a whole discussion of the factors we mentioned earlier. You have the Baker case, which is still the governing precedent on that. We mentioned it a bunch of times already, but that's the case that sets out the both the framework and the standard of review for an issue of procedural fairness. And you'll recall I said earlier that the Baker case is where the Supreme Court said it was confused. So under Vavilov, you have a presumption of, again, reasonableness review by default. That means if you don't know, it's reasonableness. So as a litigant, you have to show a specific reason why reasonableness review will not apply. If you do not succeed in doing that, it will be reasonableness review. You have the burden to rebut the presumption and establish that a different standard will apply. The Baker case said it's neither really reasonableness review nor correctness review. Assessing a decision will depend on whether the person knew the case to be met and had the ability to meet it. So essentially said that the procedural fairness obligations, right, will depend, and whether or not they'll be met, will depend also, namely upon generally the impact of the decision on the person's life. So page 286 is where it's set out. The question to be posed in every case is whether the procedure in that specific case was fair, impartial, and open in the circumstances, which is basically what I just said. And we will pause there for the purposes of erasing the board.